1534, the New France colony was established in North America. North America means the present-day Canada. It was earlier known as North America. In 1534, New France was established in this part of the globe, which was known as North America. Thereafter, the Britishers also entered into this territory, and the permanent settlements of the French people started in the year 1608. So the process of settlements, process of acquisitions started in the year 1534, and permanent settlements were established by the French people in 1608. Then there was a war for 7 years between the French people and the Britishers. And finally the Britishers won that war after a strong, long battle of 7 years. And there was a treaty that is called Paris Treaty, which was entered in the year 1763. Thereafter, the Britishers dominated in the North America. Then it was known as British North American Territory. The major part of a province, which is now present day known as Quebec province, was dominated by the French people. And finally, the Britishers started ruling the British North American Territory. They formulate and apply the laws which are made by the UK Parliament, that is called Westminster also. And there was no freedom struggle like in India or maybe like in USA. There was no freedom struggle. And the process of transferring of power from the Britishers to the Canadians was a very slow and peaceful manner, in a peaceful manner. And in the year 1867, the UK Parliament passed an act which was called British North American Act. Now this was passed by the British Parliament for the administration of the territories of British North America. Then there were certain drawbacks. Those were slowly and steadily removed, and finally this process ended in the shape of Canada Act 1982, wherein the British Parliament was completely transferred the power to the Canadian Parliament in all respects, and the British Parliament has no role in law over the administration of the Confederation of Canada. So this is a small part of it. Now we will discuss in the perspective of the syllabus given by the NCA. Now from January 2022, the syllabus has been revised, and now it has been further explained and few chapters have also been added. Now this syllabus provided by the NCA is divided into 4 parts. And before discussing this part, I wish that you must read the complete syllabus of NCA. Syllabus doesn't mean the prescribed chapters. Syllabus means right from the first word to the last word given in that syllabus of Canadian constitutional law. It's very, very important. Why? Because they have given the scope of the examination as well. They have given the references which are required. They have given the chapters of a particular author to be read in a particular chapter. They have referred to the specific case law decided by the Supreme Court of Canada in a particular chapter which is required. So it is in detail. So by reading this, you will get the exhaustive information that what is relevant and what is irrelevant. What are the basic references? What are the basic materials which are required for the preparation of this exam? And what is to be asked by the examiner in the examination and how it is to be attempted. They have given the sample papers also. So please read each and every word carefully of the Canadian constitutional law syllabus, which is available on the website of the NCA. It is nca.legal. You just go to the Google and then NCA legal. Now this part is syllabus of Canadian constitutional law. It is revised in January 2022. Revised for January 2022. Now this is the part where I am saying scope of the subject. Now you just read all this scope of the subject. I am not repeating it. It is available on the website. You just go through it and understand it. If you have any doubts, we will discuss in the subsequent sessions. This is the process of examination. Then the required readings. They have given everything. They have given the links also, and when you will register for this examination, they will provide you the access to these websites also. Then topics to be covered and required readings. So this is the first part. It is basic concepts. Basic concepts covers two chapters: sources and nature of the Constitution, and second is the amending procedure. Now we are concentrating on first part 1, that is the sources of the Constitution. It includes sources and nature of the Constitution, and second is the amending procedure. Now when we are discussing sources of the Constitution, there are 4 parts. Sorry, there is some problem. Yes. Now this is part 1. This is basic concepts. Then there is a part 2. It is distribution of legislative powers. Then there are chapters contained in this part 2. Similarly, there is a part 3. It is aboriginal rights and the Constitution. It again, just have a look. Introduction, Constitution Act 1982. They have specifically provided section 25. Again, I am missing that part. Sorry. Section 25 and section 35. And then the Peter Hogg, who is the author of Canadian constitutional law, is the recommended book by the NCA, and Peter Hogg chapter 28. Specifically, the provision of the statutory law, the particular chapter of the author is also given in the syllabus. Similarly, in the next chapter, you just find name of the case law with citation. It is given under the aboriginal rights. So, and the part 4 is the Canadian Charter of Rights and Freedoms. Again, same, there are 8 chapters. Again, each chapter they have specifically mentioned. Hogg chapter 36, Charter of Rights. Hogg chapter then the Constitution Act section 32. Then the case law also. So they have exhaustively defined the syllabus. So we have to see only as per the syllabus given by the NCA to study and read the relevant chapters, relevant material which has been prescribed by the NCA in the syllabus. So this is one aspect which is very important. So we should not go for A notes, B notes, C notes, D notes. No. We have to concentrate on one part, that is the particular sessions where I will try my level best to give you the basic understanding of each and every topic. I will provide you the handouts from the Peter Hogg and the relevant case law. We will discuss in detail all these things. Then we have to understand what is the pattern of the exam. Then how to perform, how to attempt those questions which are put in the examination. And the most important last part is, it is an open book examination. We should not keep the book along with while appearing in the exam. It is very easy. You are sitting in your home, you are sitting in your office, on the laptop you are appearing in the examination and the book is available. If you are not clear about the understanding of the concepts, if you are not aware where this particular topic and relevant material is available, the book is not helpful to you. So there is another technique we will discuss in detail, how to maximize the benefit of that open book examination, how to make a relevant notes, a relevant topics at the time of appearing, during preparation and at the time of the examination. We can maximize our benefit of that book, open book examination. So this is a little bit of introduction. Now we'll start with the chapter sources. How we'll go along with it? There are 4 chapters, approximately 4 parts, 25 chapters, and we will be holding these sessions on every Saturday and Sunday, same time, and hopefully within 6 sessions we will complete the whole syllabus along with the discussion on each and every topic. Today I am not able to provide you the link for downloading my app. Tuesday I will get the same. You can download my app. In the app you can create your account permanently. The videos which we are having the live session, 1. Second, the handouts, the important questions, and we may also provide the relevant answers to those questions also. Maybe not in exhaustive manner, but we will provide you some indications, some hints how to attempt those questions. So hopefully by the next session we will get today's handouts, the lecture of today's handouts, and I will provide you in advance the handouts of those sessions which we are going to discuss in the next week. Now today we will start with sources of constitutional law. Sources of constitutional law, there are sources and nature of constitution. By the Act of 1867, the Confederation of Canada was established. It is the province of Canada and 2 other provinces which constitute the federal body of Canadian system. Now, when we are studying about constitutional law, you are all well aware from where the constitution comes. Constitution is the basic concept of the establishment of a governance in a particular nation. Like we have a Constitution of India, it establishes 3 organs. We have adopted a federal structure. There is a parliament and there are states. There is a center, there is a state, there are states. So similarly, the 2 provinces and 1 province of Canada, they had joined under the British North American Act 1867 and created the federal structure that is called Confederation. Truly it is not Confederation, but still we can, for the purpose of ideology, we can say it is a confederation, that all the 3 provinces joined together and created a confederation where there is a central body in the shape of a federal parliament and there is a regional body in the shape of provincial legislature, or provincial body we can say, not legislature. Again, there are 3 organs. One is a legislature for making the laws. There is an executive for implementing those laws. And third is the adjudicatory body, that is the judiciary. So there are 3 organs which have been established under this confederation, under the BNA Act. It is known as British North American Act 1867. Though a progress was made, still it is a British colony. Queen is still the executive head. Privy Council is still the final adjudicator. Even the Supreme Court of Canada was not established under the BNA Act 1867. However, some part of the transformation of power was given under this act. There is section 91, 92, which provides the distribution of power among the central body and the regional bodies. However, there are 2-3 major drawbacks also. One, there are no Charter of Rights, or here we can say the fundamental rights. Those were not given any constitutional status by BNA Act 1867. There is no amending power given to the Federal Parliament of Canada. The Prime Minister and the Cabinet, their role, how they are constituted, how they would work under the Act was not defined. The office of the Governor General was not established, but it was still existing. So the preamble of 1867 Act opens with the word, all the conventions, I can say in my own language, that all the conventions which are prevalent in UK are applicable in Canada also. Regarding amending procedure, again, UK Parliament is the final authority to amend the BNA Act 1867. Regarding the civil liberties, whatever are available by way of conventions in UK are available with the Canadian people, but it is not actually translated into the shape of a law in Canada. However, there was no strict demand was also not there. But finally in 1875, yes, Supreme Court of Canada was established. This Supreme Court of Canada was not established under the Constitution BNA Act 1867, but by an ordinary federal legislation. And still the Supreme Court of Canada is working under that ordinary legislation. Then under the 1867 Act, the UK Parliament may prescribe, under the 1867 Act, the provision has also been made that the other provinces of Canada may join the Federation. There is a provision contained in that, and in view of that provision, all the provinces started joining from time to time, and finally in 1949, the last province, Newfoundland and Labrador, joined the Federation of Canada in 1949. So there are 10 provinces and 3 territories. I have posed this question in the WhatsApp group also. Now, why 10 provinces and 3 territories? Those 3 territories are not given the status of provinces. Why? This is my question to you. Please answer this question in the next session. Find out what is the reason. Now, to remove the anomalies, to remove the drawbacks of 1867 Act, certain small statutes, imperial statutes were passed either by the UK Parliament or to supplement by the Federal Parliament of Canada also. And finally in 1960, the Canadian Bill of Rights was also passed. This Canadian Bill of Rights was passed in 1960 by the Federal Parliament. And the condition was that this Canadian Bill of Rights is only applicable against the federal laws, not against the provincial laws. In case there is a violation of any of the rights contained in the Canadian Bill of Rights by the federal law, then the person can challenge it, and the Federal Parliament is bound to obey and to comply with all the rights contained in the Canadian Bill of Rights. However, in case a provincial law violates any of the rights contained in the Canadian Bill of Rights, still that law holds good even though it is in violation of any of the right contained, any or all of the Canadian Bill of Rights. So, Canadian Bill of Rights was not applicable against the provincial laws. There was a strong demand, and finally the Canada Act 1982 came into existence. Again, there is a very interesting story. It is not a transfer of power by way of any rebellion or rebellious attitude or any freedom struggle movement, but again a very peaceful transfer of power from British Parliament to the Canadian Parliament. But the Canada Act 1982 was passed by the UK Parliament. It is not passed by the Federal Parliament of Canada, but by the UK Parliament. And the very interesting part is how this process was adopted. I'll just discuss with you. This is Canada Act 1982. How it moves? It moves with, there was a request after 1867, because there was no amending provision under the 1867 Act, but a convention was developed. Whenever there is a demand for change of law, a convention, there is a convention we will discuss in detail later on. And finally, there was a consensus on that part, that whenever Federal Parliament of Canada made a request to the UK government for certain amendment, then the UK government laid that law or bill before the UK Parliament, and the UK Parliament passed that bill in the shape of a statute or an act, and that had the applicability in Canada. Now, in this process also, the Canadian Parliament made a request. This Canadian Parliament made a request to whom? To the UK government. Because the Trudeau Senior was pushing hard for the Charter of Rights. He was a champion of those freedoms to be given to the Canadian people. And it was possible only if the status of these rights be given as a constitutional status. And the requirement is that all provinces should come forward, at least majority of the provinces should come forward and give their consent. And finally, he prevailed upon the 9 provinces, except one province which has given the dissent, that is Quebec. 9 provinces gave the consent for this Canada Act, and on the basis of the consent given by 9 provinces, the Federal Parliament made the request to the UK government to pass this Canada Act 1982. And finally, the UK Parliament passed this legislation, that is Canada Act 1982, which has only 4 sections. That's all. Now with this Canada Act 1982, there is a complete transfer of power from UK Parliament to Canadian Parliament. Now the UK Parliament lost its legal status qua the Canadian legal system. So the final legislative authority now vested with the Canadian Parliament. This is one major part. Second, this Canada Act 1982 contains a constitution, Act 1982. This is as a schedule. Just keep in mind, this is very important. It is not an independent legislation. Constitution Act 1982 is not an independent legislation, but a schedule attached to the Canada Act 1982. So this was a complete code in itself. It contains the amending power, which was not earlier available. Second, it contains the Charter of Rights. It contains the Charter of Rights. Two major drawbacks which were there in the 1867 Act were removed by this Constitution Act 1982. That is, the amending power has been given to the Canadian Parliament. Second, the Charter of Rights have been introduced, and the basic rights have been declared as the constitutional rights by this Constitution Act 1982. And the third and the most important part is the BNA Act 1867 was not repealed. Note down this, it was not repealed. It was not repealed. A BNA Act 1867 was not repealed by Canada Act 1982 or by the Constitution Act 1982. So it still holds good as a law. One. Second part is the name of this act has been1867 It is now not BNA Act 1867 but a Constitution Act 1867. So the Peter Hogg, as a jurist, has criticized this nomenclature because he says it is a confusion created by the legislature, but it is the opinion of a jurist, but still it is applicable and enforceable law in Canada. So meaning thereby now the Constitution Act 1982 has section 52, which is very important. There are 60 sections. Section 52 declares the Constitution of Canada as a supreme law, and any law which violate or contravene is ultra vires. So the Constitution of Canada has been given the supreme authority. It is the supreme law of the land, and any law which violates, contravenes the Constitution of Canada is ultra vires. Now the question is whether this act is the Constitution or something else. Like in India we have one constitution, in Canada it is not one. It is amalgamation, it is a compilation of what? One, Constitution Act 1867, Constitution Act 1982. There are approximately statutes, imperial statutes, we can say imperial statutes, orders, which are contained in the schedule of Constitution Act 1982. And any amendment made to these imperial statutes, orders, etc., this in totality forms the Constitution of Canada. So neither the 1867 Act is the only constitution, nor the Canada Act 1982, the Constitution Act 1982, but it is a combination of these statutes and imperial statutes and the orders and the amendments made to those imperial statutes and orders forms the Constitution of India. So it is a complete constitution, and some provisions of 1867 were amended by the Constitution Act 1982, some amendment. It is not repealing of the act. So these basic acts 1867 and 1982 are complementing each other and not in contravention to each other. So like the imperial statute or the orders which are also complementing these basic acts and not contravening any of these acts. So they collectively form the Constitution of Canada. So any law, so this is the supreme law, and any law which violates this supreme law is ultra vires. Then what we were discussing the chapter sources. So first source is 1867 Act. I am only writing 1867 Act. Earlier it was known as BNA, and now it is known as Constitution Act. Then Canada Act 1982, which contains in the form of a schedule 1982, right? So these are the sources. Third, the imperial statutes. What is the meaning of imperial statutes and orders? Now, we have already discussed 1867 Act. There were certain requirements for a new law. Then those laws were passed by the UK Parliament. Those were called imperial statutes. And some orders by the executive authority, maybe under the seal of the Queen, have been passed for the smooth running of the administration in Canada. Those are the orders. Thereafter, certain amendments are made to these imperial statutes or these orders. Then those are also part of it. So this is again the source. So first source is source of constitutional law in Canada. First is 1867 Act, 1982 Canada Act, which has Canada Constitution Act 1982, then the imperial statutes and orders and the amendments made to it. So these are the sources. Then what are the other sources? Privileges, conventions, exactly same privileges. We have given the constitutional status to privileges under our Constitution of India. But this is again based on conventions. And they are following the UK conventions regarding privileges. What are the privileges? The privileges means the assurances, protections given to the legislatures while performing their legislative functions. So certain privileges have been given to them while discharging their legislative functions. And conventions means where a certain pattern of behavior has been adopted and given the legal sanctity by the interpretation of the courts as well. Those conventions takes the shape of a law, though not, we can say, codified, but it is a uncodified law. Those are also sources of constitution. Sources means from where this constitutional law emerges, from where this constitutional law is coming forward, from where we are getting this constitutional law. So these are the sources of constitutional law. Second part of this chapter is nature. Nature of constitution. What is the nature of constitution? Is it federal or not? Strictly speaking, ideologically speaking, it is a federal structure. What is the meaning of federal structure? Federal constitution where there is a central body and there are regional bodies, and a composition of the process of governance is a federal structure where some powers are vested with the central government, a central body, certain powers are vested with the regional bodies. Regional bodies are independent in performance of their functions within their own purview. Similarly, the central body is independent of performance of its own functions within its scope of its own powers. Where there is a conflict, there is a arbitrator in the shape of a judiciary. So this is called federal structure. And question is whether this is the nature of the Canadian constitutional law or not. Let us examine it. In 1867, province of Canada plus 2 other provinces, find out the names. I am not giving the names of other 2 provinces. They joined together and created a confederation. I am using the word federation because they are joining together these 3 provinces with having a federal parliament as a central body. So there is a central body in the shape of a federal parliament and a federal executive also. Similarly, these 3 provinces are independent provinces within the structure of federation. They have their own independent legislature and executive. This federal body, the central body, has its own legislative and executive functions. And section 91 and section 92 of this 1867 Act gives the distribution of power. Like in India, we have 3 lists: union list, state list, and concurrent list. But in Canada, there are only 2 lists in the shape of section 91 and 92. Section 91, all the matters, there we call matters. All the matters which falls or prescribed under section 91 of the 1867 Act, the federal parliament has the power to legislate. Similarly, all the matters which have been prescribed under section 92 of the 1867 Act, these provinces have the power to legislate. So the regional body and the provincial bodies have their independent existence, though they are coexisting in their own sphere. So we can say this is a federation. Now question again is where the ancillary power vests. The word used is ancillary power. In case there is a conflict or any matter which is not prescribed under section 91 and section 92, then who will legislate? This is also interpreted by the courts. We will discuss that case law also. So this power is vested with the federal parliament. This part is vested with the federal parliament. Meaning thereby the tilt is towards the central body. So it is not a true federation. It is not a true federation. But still the whole system works in the shape of a federation. So this is the nature of this Constitution of Canada. Next time we will